He received
Yes.
500 shillings.
Yes.
Out of 1.6 million.
Yes.
1.6 million.
Exact.
Now, and you recovered one laptop.
We recovered I said
No,
we recovered
read
laptops.
Read your supporting affidavit.
We recovered laptops.
Read your supporting affidavit. To the third respondent specifically. What did you recover? One laptop. That is what your supporting affidavit says.
SIM
right?
cards.
Sorry?
SIM cards.
I'm asking specifically about the laptop.
Yes.
One laptop.
Yeah.
Is it unusual to recover one laptop from someone?
May I explain for you further?
Just answer the question. You can have
There is a reason why I recovered.
Is it unusual? That is the question. Is it unusual to recover one laptop from one person?
Yes.
Unusual
Because
to recover,
may I respond to you? The reason why I recovered the laptop, if you see the transaction,
hold on.
The first
Your
transaction,
Honor.
numbers,
Yes,
there are many.
there are many.
Yeah.
Is his number, the third respondent's number there?
There is. I can confirm it from my file here.
Yes, please.
Yeah, please. Which ends with the 44
Yes.
4445.
4445.
Yes, Eric Getonga.
All right. Now, how much did he receive?
In total, he received 500.
500 out of
1.1,640,000.
He received
Yes.
500 shillings.
Yes.
Out of 1.6 million.
Yes.
1.6 million.
Exact.
Now, paragraph 10. Paragraph 10 of your supporting affidavit, you are saying he was arrested at Kahawa Wendani, right? And you recovered one laptop.
We recovered laptops. I said we recovered laptops.
Read your supporting affidavit.
We recovered laptops.
Read your supporting affidavit. To the third respondent specifically. What did you recover? One laptop. That is what your supporting affidavit says,
SIM
right?
cards.
Sorry?
SIM cards.
I'm asking specifically about the laptop.
Yes.
One laptop.
Yeah.
Is it unusual to recover one laptop from someone?
May I explain for you further?
Just answer the question. You can have
There is a reason why I recovered.
Is it unusual? That is the question. Is it unusual to recover one laptop from one person?
Yes.
Unusual
Because
to recover,
may I respond to you? The reason why I recovered the laptop, if you see the transaction, hold on.
Your
The first
Honor.
transaction, immediately the line was activated. The money was sent to the
Your Honor,
third respondent.
Just respond to the way he's asking you.
is it unusual to recover one laptop from one person?
Yeah, if it is there,
It is unusual to recover one laptop from one person.
yeah, it is what I forgot. And it is linked to
Everyone
it.
has one laptop.
Yeah, but there is a reason.
All right. Now, you are also saying that you recovered some SIM card templates from the third respondent. How many?
There is.
How many?
There are SIM cards.
Do you say that in your supporting affidavit?
Yeah,
You
I
don't.
mentioned.
You don't.
I mentioned.
You have said.
Check there.
You have said the
SIM
third
cards.
respondent. Hold on. The third respondent was arrested in Kahawendani area in his rental house, where the recovery was made one laptop and some SIM card templates. You have not said the number.
I didn't say.
You didn't say
that.
that.
I
No, you
showed
can.
the,
That is
to
a
the
very
affidavit
simple
that
question.
I recovered.
Don't
the
make
SIM.
it difficult for me.
Yeah, I
You did
recovered
not
SIM
say
card.
SIM card plates, not SIM cards.
Yeah.
From the third respondent.
Yeah.
So at this point, you're not telling the court the number.
No, I didn't.
You
give
didn't
out
say
the number. Yeah.
And you're also saying that it's just one.
Not one. SIM cards.
Oh, one laptop, that is, sorry.
One laptop.
One laptop and SIM card plates.
Yeah.
And thereafter, the other nexus to him being there is 500 shillings out of 1.6 million.
Yeah.
Very
Because this is an organized crime.
No, hold on.
This is an
Just
organized
answer my
crime.
questions.
Yeah.
It's fine. You can do your rebuttal or rejoinder later.
Yeah.
500 out of 1.6 million. Just
He
confirm that.
received without the consent of the complainant.
Now, paragraph 14. Releasing the court, releasing the respondent. I want you to focus specifically on the third respondent, right?
Yes.
Is that okay? He may interfere with pending or ongoing investigations.
Yeah.
How?
Because the reason, if you may check the first activation of the SIM card of the complainant,
Yes.
And the first transaction,
yes,
which was done, was to his mobile phone number.
All right. Now, when was this crime committed, allegedly? When was the alleged crime committed?
On 8th.
On 8th
of
September
25.
2025, last year.
Yeah.
How many months ago is that?
Around 4.
Around 4. Do you have any evidence that he has interfered with the investigations?
He can, yeah.
No, you don't have that he has.
I have that.
You are
evidence.
saying he can.
I have that.
You have that evidence.
Yeah.
Have you supplied to the court? Do I have it in your application?
And that's why I'm seeking this.
No. Do I have it in your application?
In my application.
You're familiar with
I'm
Article 49?
Days for the
Don't
investigation
argue,
to be complete.
Don't argue. You are familiar with Article 49, 1H of the Constitution, right?
Yeah.
It is the reason why you are applying for this application. It is the basis in law that you are applying for this application.
Yeah.
It says compelling reasons, right? And you are saying that you want this court to detain him for 10 more days,
yeah,
and you are
exactly.
saying you have that evidence, but you are not submitted. You have not submitted it to the court at this point. Do you understand how absurd that sounds? Do you?
Your Honor, he has a consent from the complainant that he sent him those cash.
Ayo, he received 500 shillings.
Yes, from who? From who?
He did not control. Does he control the people he received
What was
money
the
from?
motive of immediately he received money, he transferred it to another SIM card? What was the motive?
You do not ask the questions. I do ask the questions. Your Honor, we submit that nothing that the IO has said would warrant this court or the IO to override his constitutional right under Article 49, 1H of the Constitution. Your Honor, I also want to say that case law has established that for a court over the IO to submit an application where an individual should be detained for more than 24 hours, reasons must be concretely and firmly established. The IO has not presented that before this court. Lastly, Your Honor, I just want to say that I do have a discharge form for the wife of the third respondent. Last week, she had a medical emergency, maybe you can, which I would not want to disclose in open court. She had a medical emergency and a serious one at that. I would call she was bereaved. This is the second time. The first one happened in June of last year. Your Honor, I pray that you may find liberty and at your discretion that you release the She's the mother. Apologies for that. I sincerely, the only nexus that the third respondent has to the allegations is that he received 500 shillings. Now that is a factual matter, as the prosecutor has said, and it will be established during the trial. But I pray, Your Honor, that 500 shillings is not enough, Your Honor, to override constitutional rights. And I just want to say, finally, and to rely on the case of Betty Jemutai versus Republic 2018 at the High Court in Cabernet. The High Court said by taking witness statements, call data, and securing forensic reports on cybercrimes aspect of the case, these are all things that can be done when the accused person in that case was out of custody. He has not submitted that there is any evidence that he will interfere with this crime, with any witnesses, if there are. And I pray, Your Honor, that you may find it in your heart, based on constitutional grounds, that he is released to support his wife who is bereaved. If this court finds, I believe that based on the nature of the accusation or the nexus to him, cash bail would be sufficient. However, if the court is inclined to even secure bonds or sureties, you have seen the mother is here, the wife is here, his friends are here, as well as his cousin. Your Honor, if the purpose of bail and bond is to secure his release, just a reasonable amount will be enough to do so. Thank you, Your Honor.
The investigating officer for the case of stealing, which was reported at Parklands Police Station, Vide OB number 28 of 8th of September 2025 by the complainant one Bet Kipsang. Your Honor. Your Honor, while in the club at around 4 a.m. he noted that his mobile phone has been stolen, was missing, Your Honor. He made a report to Parklands Police Station. Your Honor, the investigation started. To that lead, Your Honor, the 3 respondents who are before this court, Your Honor, were arrested, Your Honor, for the reason that the complainant, his phone was stolen, and immediately the phone was stolen, Your Honor. By 6:54 a.m., Your Honor, already whoever had stolen, Your Honor, started, they accessed to the bank account of Standard Chartered, and they transferred money from Standard Chartered to KCB account, totaling amount of 1.640, 1,640,000 from his account, Your Honor, and the said amount, Your Honor, was wired to the different mobile phone numbers, Your Honor. Approximately, to my record, Your Honor, it's 18 numbers, mobile phone numbers, which had been registered under Prox. Honor, the said amount was wired to different mobile phone numbers, which had been registered under the Prox names. And others were withdrawn direct to the M-pesa agents, Your Honor. And the investigation started, Your Honor. During the investigation, Your Honor, was established that respondent number 3 on 8th, Your Honor, he received, immediately the line was swapped, he received first 300 shillings to his mobile phone number. At the same time, he received again from Standard Chartered account another 200. In total was 500, and he transferred to his alternative number, which is still registered under his names. That's what leads us to arrest him. Again, Your Honor, to the first respondent, Your Honor, he used Prox numbers which he shared with email number on the day of incident, Your Honor, with his genuine number, which is registered under him. The same, Your Honor, the second respondent, he shared with his mobile phone paired with the mobile phone which transacted from the which received money from the account of the complainant.
Seeking to have 10 days custodial orders for the respondents hearing for purposes of investigation. The investigating officer has submitted that the respondents were arrested yesterday from different locations and from rental houses, and stated that the same may pose a challenge to him, and also stated that the said witnesses may interfere with the investigation. He has also stated that he requires time for investigation of the said SIM cards together with the mobile phones and laptop required from the respondents. This application has been opposed by the third respondent through counsel, Mr. Okello, who has submitted that the investigating officer has not placed any tangible evidence before court to show that the third respondent may interfere with the witnesses. He has also told the court that the accused persons will not be required to, in the investigations that will be going on for the forensic analysis of the SIM card and the laptops, and also stated that the third respondent has a personal matter which he intends to attend to and prayed that they be granted bond. He relied in an authority which stated that where the accused, the rest suspects are not required for purposes of investigations which are ongoing, then it will be prejudicial for them to be retained in custody while the investigations were going on, and prayed that the third respondent be released as his family members were before court. The second and the first respondent had no objection to the order, save that the said prayed that the said debts be reduced. In concurrence with the investigating officer, the prosecution also insisted that they be allowed to have the said application allowed, and the alternative that stringent orders be given so as not to interfere with the investigation. In my analysis, I have considered the application and the objection raised by the third respondent and the response made by the second and first respondent and that of the prosecution. I will agree with Mr. Okello appearing for the third respondent that nothing has been placed before court to show that the three respondents are at light risk and that they would interfere with the investigation and how they would help in the investigation of the said forensic analysis. The role of the court is to balance the rights of the suspect and that of public interest on matters of justice. Therefore, the application to have custodial orders for 10 days will be prejudicial to the respondents who are before court, since there is no evidence seeking the same. Therefore, the court will allow the application, will decline to allow the application and direct that the respondents herein will be released on a bond of Kenya shillings 200,000 with a surety of similar amount, or a cash bill of 50,000 each with 2 contact persons. They'll be directed, the court will further direct that they will respond to summons issued to them by the investigating officer for purposes of investigation. They will also be allowed to have legal representation in the conduct of the said investigations.